Hello viewers, I am Dr. Daniel Matthew from National Law University, New Delhi. I welcome you all today to an intriguing topic on transfer by ostensible owner, concepts and legal provisions under Section 41 of the Transfer of Property Act. In this session, we will explore how this unique provision provides an exception to the general rule of property transfer. Very specifically, we will examine the circumstances under which a person who appears to own property but is not the true owner can transfer property to a third party who acts in good faith and takes reasonable steps to ensure that the transferor has the authority to do so. The concept of ostensible ownership plays a pivotal role in safeguarding bona fide purchasers in property transaction. At the same time, it also raises several legal complexities, especially in light of other related laws such as Benami Transactions Prohibitions Act, etc. By the end of this presentation, you will have 1. A clear understanding of how Section 41 operates, 2. The key requirements for its application, and 3. The legal protections which is available to both the transferees and the real owners. By the end of this video lecture, you will also be able to 1. Define the concept of ostensible owner and understand the exceptions to the general rule of property transfer. 2. Identify the key legal provisions under Section 41 of the Transfer of Property Act. 3. Recognize the essential conditions required for the application of Section 41. 4. Understand the importance of concepts such as consent, consideration, good faith, and reasonable care in property transaction. And 5. Explore the relationship between Section 41 on the one hand and other related laws, as we had said earlier, the Benami Transaction Act. In addition to the 5 above, you will also be able, after this lecture, to analyze real-world examples to apply the principles discussed in this section. Therefore, in this video, we aim to 1. Clarify the meaning and legal implication of ostensible ownership. 2. Explain the legal provisions contained within Section 41 itself of the Transfer of Property Act. 3. Highlight the conditions for a transferee to be protected under this section. 4. Examine relevant case laws to understand, in fact, better understand how courts have interpreted the application of Section 41. 5th, address the role of consent and good faith in the validity of property transaction. And finally, discuss the practical impact of these legal provisions on property dealings and the rights of all parties involved. With this brief introduction, let us delve into the topic of Section 41 of the Transfer of Property Act. Now, this section makes the provision relating to transfer by ostensible owner. The section provides where, with the consent, express or implied, of the persons interested in immovable property, a person is the ostensible owner of such property and transfers the same for consideration. The transfer shall not be voidable on the ground that the transferor was not authorized to make it, provided that the transferee, after taking reasonable care to ascertain that the transferor had power to make the transfer, has acted in good faith. This provides an exception, as can be seen, to the general rule of transfer of property. So, what is the general rule? The general rule is captured by the maxim nemo dat quod non habet, which means that no one can transfer a title better than what they themselves possess. To put it differently, a person cannot transfer a right or title to a property greater than what he himself has. Now, an exception to this principle is that where a person who is the actual owner of the property permits, allows another person to present themselves as the owner, this person is called as the ostensible owner. Then, a third person who transacts with the other person, that is, ostensible owner, in good faith may acquire a good title to the property as against the original owner. The term ostensible means apparent. Therefore, ostensible owner is someone who seems to be or appears to be the owner, but in reality, an ostensible owner is not the true owner. At the same time, such person is neither a trespasser nor in unlawful occupation of the property. Such a person has at all times the consent of the real owner, whether such consent is explicit or implicit. So, for instance, two brothers, Pankaj and Prakash, who are joint owners of the property, with only Prakash managing all affairs and taking all decisions about the property, including public dealings. All of this is known to Pankaj, who allows Prakash to behave this way. Now, Prakash sells that property to Bhuvan. Bhuvan, who has purchased this property by paying consideration after making reasonable inquiries, Pankaj cannot later object to this sale, claiming to be an innocent party because it, that is, the sale, was conducted in the first place that made other people believe that Prakash had all the powers as regards the property. And this allowed Prakash to commit the fraud. So, to put it differently, the true owner is now estopped from resisting the transfer against the transferee on the ground that the transferor was not competent in law to transfer the property. In such instances, the transferee would be considered to be a bona fide owner. However, not all such instances would be considered as falling within the scope of this section. Thus, the essential requirements for the application of Section 41 are: 1. Transferor must be the ostensible owner. 2. Transfer of property to the ostensible owner must be with the express or implied consent of the real owner. 3. Transfer by the ostensible owner must be for consideration. And 4. Transferee must have in good faith acted after taking reasonable care in ascertaining that the transferor has the power to make the transfer. Fifth, the transferee acted in good faith after making reasonable inquiries. Now, all these conditions must be fulfilled together simultaneously for Section 41 of the Transfer of Property Act to apply. Now, one of the first questions then therefore that arises, and we looked at it previously, would be who is an ostensible owner? To repeat, an ostensible owner is someone who demonstrates signs of ownership without being a real owner. Now, in Jaya Dalal Podar versus Bibi Hazara, the Supreme Court decision of 1974, the Supreme Court of India held that whether a person is an ostensible owner or not is a substantive question, response to which is dependent on the specific facts and circumstances of the case. In this context, let us also look at another important idea, that of Benami transactions. The law relating to the transfer of property by an ostensible owner under Section 41 of the Transfer of Property Act are now subject to the provisions of the Benami Transaction Prohibition of the Rights to Recover Property Act of 1988. The law provided under Section 41 of the Transfer of Property Act therefore stands modified, except where Benamidar is a copartner or a trustee standing in a fiduciary capacity. Now, the Supreme Court of India in Mangatbhai Amal versus Rajeshwari, a 2020 decision, outlined some of the key factors that is taken into consideration to decide the question of ownership. 1. What is the source of purchase money? 2. Who had the possession after the purchase? 3. The relationship between the parties. 4th, the conduct of the parties themselves in dealing with the property. 5th, who has the custody of title deeds. Now, in instances where there is more than one owner of the property, it must be shown that 1. All the co-owners consented for the transferor to be the ostensible owner, all owners. And 2. The transferee took reasonable care to ascertain that the transferor had the power to make the transfer. These two ideas were affirmed by the Supreme Court of India in Suraj Ratan Tirani versus Azmabad Tea Corporation Limited, a 1965 case. Another important concept associated with ostensible owner is the idea of consent. Now, consent of owners, as we mentioned earlier, of the property for the transfer is an important element for the operation of this provision. If there is no consent, this section does not apply. Now, while the consent can be expressed or implied in nature, it must be real consent, which means it should not have been obtained by fraud, coercion, force, or undue influence by the real or the ostensible owner of the relevant property. Further, if the real owner is under any incapacity or is incapable of giving the consent, for instance, in case of a minor or a religious endowment, no one can hold himself out to be an ostensible owner of such a property. Now, the question that arises is whether consent has been given by the real owner for ostensible ownership. This is a question of fact, and its outcome would depend on the specific facts and circumstances of the case, as we mentioned earlier. Now, as I said earlier, consent can be both express or implied. But what does it mean, or what do we mean by that? An express consent occurs when the consent is given by words, which can either be in writing or could be spoken. Now, when such a consent is given through conduct, behavior, it is termed as implied consent. It is therefore important to understand that in instances of implied consent, the real owner is aware that the ostensible owner is dealing with the owner's property, but he chooses to remain silent or does not contradict the ostensible owner's claims or behavior. This would be a situation of implied consent. However, where the real owner himself or themselves were not aware that their right in the property or they had right in the property, and because of this they remain silent, uh, then this cannot be said to be a situation of implied consent. Now, in such situations, the real owner can challenge the transfer, and the transferee will have no protection under this particular provision. Now, in Samay Singh versus Hukum Singh, a 2007 decision of the Uttaranchal High Court, it was held that by virtue of the power given by the real owners of the land, the attorney was found to be completely and fully competent to execute the sale deed of the land in question. Now, in such a situation, the purchaser had also paid the sale consideration in good faith. In this situation, Section 41 of the Transfer of Property Act will prevent the plaintiff from seeking an injunction against the sale. This concept will be clearer with another example. Suppose there is an individual P who is the husband of Q, and P has purchased a property in Q's name. Now, the property was entered in the name of the wife in the revenue records. Now, after the husband's death, his widow Q mortgaged this property to R, who took the mortgage after due inquiry, believing in good faith that Q was the owner of the property. Now, R obtained a decree for sale on his mortgage and purchased the land. But at the same time, S was in possession of the property, for S had purchased the land in execution of a money decree against P. Therefore, our suit against S for possession was decreed. Now, S was the successor in interest of P, who had held out his wife Q as the ostensible owner and therefore could not defeat the mortgage, who was a transferee in good faith from the ostensible owner herself. Similarly, in instances of joint ownership, it was held by the Chhattisgarh High Court in Manjari Devi versus Usha Devi, a 2014 decision, that where there was a joint ownership of a property, but partition deed existed between them, clearly demarcating their shares, then a transfer effected by one of them cannot be held to be a valid transfer. The court observed that the transferee had exercised no care to verify and check whether there were other joint owners. Now, in such a situation, the transferee cannot be considered to be a bona fide purchaser. Therefore, for the application of this particular provision, consent is absolutely necessary. However, this does not include an intention to deceive the transferee on the part of the real owner, nor is it essential to prove the same. The real owner may be innocent in the entire transaction, but if the transferee had acted in good faith and made proper inquiries, then they would have the protection under Section 41 of the Transfer of Property Act. Let's move further. The term transfer in Section 41 applies to voluntary transfer by the act of parties. It does not include transfers which have been made by the order of a court or through an auction sale. In such situation, the vendees claim to be a bona fide purchaser on the basis of the sale deed that was not surrendered would not be accepted. An order passed by a recovery officer to hand over the vacant possession of the property would be appropriate and proper. Similarly, it is not necessary for the application of the section that there must only be sale or exchange of property. The term transfer used in the provision includes transfer of an interest in the property. As a result, this would also apply to mortgage, and an ostensible mortgagee would be treated as an ostensible owner. Let us now move further ahead. In the case of State of Punjab versus Surjit Kaur, a 2012 decision, it was held that where a person has allowed another to occupy position of an ostensible owner with a limited estate, such as say life estate, the rule of section 41 of the Transfer of Property Act applies, but only during the lifetime of the limited owner and not available to protect transferee against the claim of revisioners. Once a person ceases to be an ostensible owner, they cannot pass on a better title than the one they had. Another important concept is the concept of consideration. It is important to remember that protection of this section is available only where the transfer happens for a consideration. Without a consideration, this provision has no application. In other words, the transfer and the transferee would not be protected where the transfer is gratuitous. Similarly, would be a situation of gifts of property. They are not protected under this section, as a result of which the real owner can challenge a gift made by an ostensible owner. You could recall from our earlier discussion that we had said that good faith and reasonable care are of utmost importance. Let us spend some few minutes on this. As I said, good faith and reasonable care are key aspects of this provision. Thus, the provision concerns bona fide intentions. That is, transferee therein has acted in honest and real belief that the ostensible owner is the real owner. This provision requires, therefore, the transferee to act in good faith while purchasing the property. It should be noted that taking of reasonable care is not equivalent to acting in good faith. These are two completely different concepts. For the application of this provision, both these concepts have to be simultaneously fulfilled. A standard rule of law is that any person who seeks equity must do equity. So, where the transferee purchases the property after making due inquiries and in the honest belief that the seller is the real owner, only in such situations the purchaser will be protected against any claim raised by the real owner. However, if the purchaser, after making inquiries, found that the person selling was the ostensible owner and not the real owner, yet goes ahead and makes the purchase, then it cannot be said that the purchaser has acted honestly. Now, in the absence of good faith, the court will presume a collusion between ostensible owner and the transferee. The Supreme Court of India in Muhammad Ibrahim versus Muhammad Yusuf, a 2007 decision, held that in a suit for specific performance, where the transfer by ostensible owner had been done by a registered document and the transferee had failed to take care to verify from the office of the sub registrar, in such a situation, the transferee was not entitled to the benefit of Section 41. Thus, mere good faith is not adequate. The purchaser should also have made reasonable inquiries. The reasonable or reasonableness means that such care that a person of ordinary prudence would take in his own case. Reasonable care is expected from everyone who claims to have purchased a property from another person. However, what is reasonable would necessarily depend on the specific facts and circumstances of the case. Where the concerned property and all parties belong to the same village, then it would be expected that the purchaser would have been aware of the conditions and situations surrounding the land, its possession, and its ownership. However, mere mention in the revenue records cannot be considered to be documents of title, and merely relying on them cannot be considered as having made reasonable inquiries. The purchase, therefore, must necessarily verify the title deeds. Such action would be considered as part of making reasonable inquiries. In Neelkant versus Siddhalingaya, a 2004 Karnataka High Court decision, it was observed that in a case involving transfer of land by ostensible owner, where both documentary and oral evidence showed that the real owner had allowed everyone to believe that the ostensible owner was indeed the owner and that he was neither in possession of the property and had no rights in the property, and these impressions were supported both by the revenue records and registered documents, then transferee's right will be protected under Section 41 of the Transfer of Property Act. Thus, any person intending to take benefit of the section must be able to show that they have made an inquiry about the transferor's title. Where the purchaser had sufficient time to inquire prior to getting the sale deed registered in his favor, but no genuine inquiries were made around the area where the property was located and parties were residing, the purchaser cannot be considered to be a bona fide purchaser. The transferee, therefore, has to show that they made such inquiries that a reasonable, prudent man would have made or would have taken to safeguard his own interest. Whether such inquiries were made before the transfer is a question of fact, but whether the inquiries were sufficient is a question of law. However, this doesn't mean that the transferee has to make endless inquiries. Now, in the case of Durga Prasad versus Special Secretary Tourism Department, Government of Sikkim, Gangtok, The Sikkim High Court in 2018 held that this section was an exception to the general rule, which is that a person cannot confer a better title than he had. Being an exception, the onus is on the transferee to show that the transferor was the ostensible owner of the property and that he had, ostensible owner, had, after taking reasonable care to ascertain that the transferor had the power to make the transfer, acted in good faith. The care required of a transferee is that which an ordinary man of business is expected to take. If the ostensible owner is in possession of the property and he also produces the title deed, the transferee cannot be expected to make roving and searching inquiries in the absence of any ground of suspicion that the transferor may not be the real owner. Let's look at, or let's expand this idea further using the doctrine of holding out. Another way of understanding the operation of Section 41 of the Transfer of Property Act is the application of doctrine of holding out. What is involved is rights of two innocent parties, and their rights are in conflict, the transferor and the original owner. The law resolves this conflict by negating the right of the party that held out either through words or action a picture different from reality. For instance, if a property is owned by A but allowed B through words and action to appear as owner, and taking advantage of these, B sells the property to a bona fide purchaser. In such situation, because A held B out as the owner of the property, A can no longer claim that his right has been violated. A subsequent transferee acting bona fide with reasonable care, is protected even if the immediate purchaser had notice of ostensible ownership. Therefore, what becomes important here is the idea of burden of proof. Since in instances pertaining to transfer by ostensible owners, there is a conflict of rights, each party bears the burden of proof to substantiate their right. In the first instance, the transferee has the burden of proof to show two things. One, that the transferor is the ostensible owner, and two, that he, transferee, acted with reasonable care and in good faith. Now, once this proof has been discharged, the owner shifts on to the other party that wants to defeat the right of the transferee. Whether real owner or those deriving their rights from the real owner want to defeat the right of the purchaser, then the burden of proof lies on them to show that the purchaser was aware that the ostensible owner was not the real owner. In other words, it is necessary to show that the purchaser had constructive notice of the real title, and the burden of proof in this regard would lie on anyone wanting to defeat the title of the transferee. If the transferee fails to discharge this burden of proof, then they have no protection under Section 41 of the Transfer of Property Act. Similarly, if those who want to defeat the right of the purchaser fail to discharge their burden of proof, the transferee would receive protection under Section 41. Mere bona fide on the part of the purchaser or the pledgee is not adequate, not enough. They will have to prove that by some act or omission, the true owner had forfeited the right to recover back his possession. It is important, therefore, that the party resisting the claim of true owner provides strict proof of the right and equities that has arisen in their favor. Therefore, in case of an allegation by a person that the property conveyed to another person belongs to him, then the person bears the burden of proof to show so. In conclusion, we can say that Section 41 of the Transfer of Property Act provides an essential safeguard for bona fide purchasers in property transactions involving an ostensible owner. By ensuring that the transferee who act in good faith and with reasonable care are protected, the law promotes both fairness and certainty in property dealings. However, it also highlights the importance of consent, the role of the real owner, the need of thorough due diligence by the transferee. This provision, while offering protection to bona fide purchaser, also underscores the complexity of property law, especially when issues like joint ownership, Benami transactions, and fraudulent transactions come into play. It is essential for everyone involved in property transaction to understand these nuances to avoid disputes and ensure that their rights are protected. Thank you so much for watching this video. Please ensure you explore the related case law and provisions further for a complete understanding of how this principle operates in practice. If you are dealing with property transaction, remember that due diligence and good faith are your best protection. Stay informed and take care. Thank you.